That is case number 18CA0069M. Each party is represented by counsel, so each of you will have 15 minutes to present your argument, and the appellant may reserve up to 5 minutes for rebuttal time. No children involved in this one, right? I can recall. All right, so that being the case, we've read the briefs and are ready to proceed if you are.
Thank you, Your Honors. Good morning. May it please the court.
Oh, I'm sorry. Also let me know if you're going to reserve any time, and I'll keep track of that for you.
Thank you, Your Honor. I would respectfully request 3 minutes of rebuttal.
3 minutes, all right.
Thank you. May it please the court, Mr. Bellucci. My name is David Sheldon. I represent Mr. Beal in this appeal. As you can see from my brief, there's only one issue in this case, only one assignment of error. That assignment of error is that the trial court abused its discretion in not allowing counsel an opportunity to file a motion to suppress in this particular case based on the Carpenter decision, which I cited in my brief. I alluded or analogized to this court's previous decision in State v. Justice, wherein the appellant in that case had filed a motion to suppress evidence. He was out of time, I think, by a week or something to that effect. I can't recall how much he was out of time. But in his motion to suppress, he explained to the court why he was late in filing it. And he explained that he just recently received discovery, and I think he gave another reason. But the court in that case the trial court in that case went on to discuss the merits of his motion to suppress and did not address the timeliness of his motion. And because of that, this court reversed and remanded to the trial court to allow counsel or to have the court make findings of fact as to whether or not the motion was timely and reasons in support of the motion being untimely. This is analogous because in this specific case, it is not a motion to suppress, but it's a motion for leave to file a motion to suppress. And counsel cited a decision that was issued by the United States Supreme Court 4 days before the trial date. Now, I understand this is on the eve of trial. The judge has a jury wait, and we all understand that this is a last-minute effort by trial counsel to bring to the attention of the court a possible suppression issue. But I give trial counsel credit 4 days before the trial date, this decision comes out. I would submit to this court that there's probably a lot of attorneys that would have missed that decision, not been aware of it before the trial date. I give counsel credit in this case for finding that decision and then citing it in his motion for leave to file a motion to suppress. I think the problem was he did not have enough time to analyze that case and present it in a very cogent and argumentative way to the trial court through a motion to suppress. So he's basically saying, Judge, give me the opportunity here to at least analyze this case, see if it's on all parameters with this case, and give me an opportunity to file a motion to suppress so you can decide whether or not this is a proper issue.
So he attached a copy of Carpenter to the motion for leave?
I don't know if he attached a copy, Your Honor. I know he cited it. I'm not sure.
He didn't have time to analyze it to attach a copy of the motion to suppress. But didn't the court, in its ruling, indicate that, in the court's opinion, Carpenter did not apply to the facts in this case?
Well, that's the problem, I think. The court's not giving counsel at that point an opportunity to do a fully briefed motion to suppress. We all know that there can be other cases out there that may be similar to the Carpenter case that may have come up to the circuit courts of appeals or may have been addressed in the state courts of appeals that he didn't have an opportunity to research all that, see if it was, he could find a case on points more with this factual case with child pornography being downloaded. Maybe he could have found other cases out there that were very similar and analogous and brought that by way of a motion to suppress to the attention of the court through a properly briefed motion to suppress. So I guess my argument is, Your Honor, let's give trial counsel an opportunity to explore this Carpenter case more thoroughly, analyze other appellate cases through the United States Circuit Courts of Appeals, through the state courts, I mean, this is a national issue. This is the United States Supreme Court. So there may be cases in other states that were analogous involving child pornography. So I think it behooves the court to at least give trial counsel an opportunity to give him leave and then file a proper motion to suppress and maybe digest these issues more thoroughly, go through all the other cases that may be out there, and then maybe make a more cogent argument to the trial court. Hey, Judge, this is analogous, and this is, Carpenter does apply, and I think, this should be suppressed. So, and that court didn't address it. The court just basically addressed the merits of his motion, saying, hey, I don't feel Carpenter applies in this case, your motion is denied. And I think justice is square on that. Let's give let's give the trial court an opportunity, number one, what were the reasons for delaying or not filing this timely? Were those legitimate reasons why you did not file this in a more timely fashion? I submit to the court 4 days before trial. He did a good job at least getting this issue in front of the trial court and saying, hey, there's an issue here, I think, Your Honor. Let's give me some time to explore this more thoroughly. So for those reasons, I would ask the court to respectfully reverse the decision of the trial court, find that the court acted arbitrarily, remand it to the trial court, and give counsel an opportunity to file a motion to suppress and fully explore these issues, and let the court decide, hey, was this timely filed? If it wasn't timely filed, why wasn't it timely filed? That was never addressed. Thank you.
All right. Actually, you'll have 5 minutes if you want to use 5 minutes for rebuttal. I'll let you do that.
Thank you, Your Honor.
All right. Good morning, counsel.
Good morning, Your Honors. And may it please the court, I'm Vince Vellucci from the Medina County Prosecutor's Office for the appellee in the state of Ohio. So I'll just start by providing some context here for this motion and just how untimely it was. It was not just untimely, it was very untimely. Beal's jury trial was set to begin at 9 a.m. on June 25th of 2018. Beal's motion was filed at 8:47 a.m., so 13 minutes before trial was about to start. Beal acknowledges, and we agree, that at this point his motion to suppress would have been untimely by 151 days. That's on that day. But Beal also did not include an actual motion to suppress evidence with his motion for leave. This was just a motion for leave. So the actual motion would have been even more untimely if it was filed at some later date. If it was actually filed at all.
Carpenter, when would he have been aware of Carpenter? Only 4 days, right?
Right. Carpenter was, I believe, 3 or 4 days earlier was what decided. The case had been pending since December 6th of 2017. That's when the indictment was filed. So,
Counsel, I'm sorry for interrupting too, but back with Judge Giudosi's question. Carpenter was decided just 4 days before, so how is that really relevant that all that time had passed? I mean, and isn't that what the real issue here is? Did the court jump ahead of itself and just say, well, Carpenter isn't applicable, it doesn't matter?
No.
Because the court, maybe should have just said, hey, we better look at why this is filed so late and what justice should be done here.
well, so the only reason given for the continuance, the request for the continuance, was the Carpenter decision. Therefore, there was nothing for the court to address other than that, than the fact that Carpenter wasn't applicable. But that wasn't the only thing that the judge said when she orally denied this. She also mentioned there have been several continuances in this case, and that directly does address the leave question. And there had been several continuances. That's why I mentioned case had been pending since December 6th of 2017. Now we're at June 25th. Case had been pending for almost 7 months.
So, counsel, I don't think you're saying, though, I'm sure you're not, that just because a case has been pending and has been granted continuances, if there's a legal change with the United States Supreme Court that would affect somebody's constitutional rights, that we just ignore that because it's been so long anyway.
And she wasn't ignoring that at all. That's why she went into the merits of this. And I think it's not something that takes longer than 3 or 4 days to figure out, because as I kind of addressed in my brief, this absolutely and clearly this case had nothing to do with this case, the Carpenter case, I should say. The Carpenter decision was, the Supreme Court made it very clear in its language. Even a cursory reading, you can see that they say this decision is a narrow decision We are talking about cell phone location information. That is it. In fact, they say, quote, we do not express a view on matters not before us, nor do we address other business records that might incidentally reveal location information. Like, for example, an IP address that was used in this case to get a physical address where the search warrant was ultimately executed.
Counsel, let's back up just if you would to whether or not this is the same as the Justice case.
Yes, highly distinguishable from the Justice case. Yes, there was a denial of a defendant's untimely motion to suppress in that case. That is where the similarities to this case end, right there. In Justice, first of all, this court did not find that the trial court abused its discretion, which is what Mr. Beal is asking you to do here. You did not find that the court abused discretion. You only remanded the case to clarify its holding with respect to leave to file the motion. Now, in Justice, the defendant's motion to suppress and the motion for leave to file it were only untimely by 14 days. Here, as I said, we're talking about 151 days. And also, in Justice, there was an actual motion to suppress attached to the motion for leave. Here, it was just the motion for leave. That's another big distinction. So the actual motion to suppress would have been even more untimely, would have required yet another continuance of the trial when it had been continued, I believe, 4 times already, and had been pending for 7 months. In fact, Beal's trial counsel implied that a motion to suppress may not be filed at all. So, again, different. The defendant in Justice ultimately pled no contest to his OVI charge and didn't go to trial. Here, the motion for leave was filed, as I said, 13 minutes before the trial was to begin, on the morning of trial. That's a very different thing.
Well, okay, let's, if we could for a minute, move away from the timeliness issue, although I understand. I think we all know from the briefs where we're talking in terms of time. I think the argument is that Justice says you address the merits instead of addressing the factors you need to address with timeliness. And, you know, the Court of Appeals usually doesn't address those types of things in the first instance. So can you speak to if it's distinguishable from Justice with respect to what the court addressed and did not address? It seems from the brief, the record says, I don't think that the trial court said, I don't think that's applicable, motion denied. Instead of saying, you've had X number of continuances, this case has been pending for this long, we're here for the morning trial, everyone knows all those facts, but did the trial court actually address those factors when it ruled on the motion, untimely motion for leave?
Well, I would start by saying, I think it's important that there was no actual motion to suppress filed here. So it'd be very difficult for the court to be focusing only on the merits of an underlying motion that does not exist. There was only a motion for leave. Now, Carpenter was mentioned, but it was very briefly. It certainly wasn't a full-blown motion. And that is really the only reason that was given for the delay. This wasn't like Justice, which was where the delay was receiving late discovery. That was the issue in that case. In this case, you know, and then the whole discovery thing was not addressed, right? So that's why this court said we need more clarification on the leave question. Here, the only thing that was mentioned was this Carpenter decision. That was the only thing the trial court could have addressed when it was denying this motion. And
was it actually ruling on the issue in the motion to suppress? Motion to suppress would have been limited to a legal argument. Does Carpenter apply, correct?
Yes. Well,
Did the court in effect rule on a motion to suppress when it said I'm denying the leave because Carpenter doesn't apply?
Well, there was no, like I said, there was no suppression motion before the court to rule on. And I think there's a very important line in Justice too, a very important holding of this court actually, that says the basis of the suppression motion may affect the trial court's decision as to whether the reasons advanced for the delayed filing constitute good cause for the delay. That means that when determining whether to give somebody leave, the court can consider the merits of the underlying petition. This court clearly said that. So even if that is all the court was doing, was considering the potential merits of how Carpenter would apply to this case, that was proper, and that was not error, according to this court. Injustice said that they're allowed to consider that. So it wasn't improper to consider that when it was considering whether to give Beal leave. And by the way, another continuance. It would not just have required leave with a trial date set out way out there. This would have required yet another continuance of a trial that had been continued 4 times and had been pending for 7 months. So again, a very different situation than what this court had in Justice. And again, this was not a hard call for the court to make in terms of Carpenter not even being arguably applicable. The Supreme Court talked about in Carpenter, like I said, the increasingly pinpoint accuracy of cell phone location information, and the fact that the government can essentially retrace a person's whole whereabouts going back 5 years, exactly where they were for the last 5 years at all times. That's how long the cell carriers keep the records, is the 5 years. The court specifically said that because carrying a cell phone is indispensable to participation in modern society, cell phone location information is not truly shared. They said a cell phone's location, they noted that it's constantly traced just by being turned on and connected to a network, meaning there's no affirmative action by the person, by the user. Now consider this case, getting a name and a physical address by providing an IP address to a cable company. That's what we have in this case. That's nothing like getting cell phone location records that detail a person's every move for 5 years. Carpenter's holding, like I said, is very much limited to cell phones, and it can't possibly be read to require a search warrant in a situation like this to get a physical address with an IP address. That was done by a subpoena, like I said, a grand jury subpoena. That's how that was obtained. A person who is sharing child pornography using file sharing software is very much engaging in affirmative action, not like a person just carrying a cell phone that's turned on. So I don't think it was difficult in 3 or 4 days to come in on the morning of trial and say that this case clearly is not applicable. The Supreme Court even said this is a narrow holding. We're only talking about cell phone location records. It's kind of a sui generis kind of thing. This is very unique in modern society that we all have cell phones now, and they can be pinpoint traced every movement. They're not requiring search warrants every time you track somebody's location, especially when it doesn't involve a cell phone. So I think that was a decision the trial court was entitled to make at that time, was entitled to consider that Carpenter did not apply. I think that's not the only thing that was being considered. The time as well, and all of the continuances and so forth. And I've cited in my brief several other cases where this court found that the trial court did not abuse its discretion in denying a motion for leave to file a suppression. So there are many, many more cases where this court has not found an abuse of discretion. And as I said, did not even find an abuse of discretion in Justice. So I would just respectfully, there's no other questions.
Well, if the defendant would have attached the motion to suppress, the motion to leave, limited to Carpenter, and the court denied the motion for leave, your arguments would be the same, right?
Yes.
So how would a defendant who truly believes that his constitutional rights were violated based on a recent Supreme Court decision protect that right to appeal? Because the court didn't rule on the motion to suppress, because he never had an opportunity to file the motion.
Well, I think he probably would have had a better chance of getting it continued if he had an actual brief filed. I can't speak for what the judge would have done, but
So you think the failure to file the motion was fatal in this case?
I don't think necessarily, but because the merits of Carpenter were somewhat addressed in the motion for leave. There was a couple lines in there that tried to compare the two cases, but at the same time saying, you know, I'm not really sure it applies either, and on the record saying, you know, we may or may not file it, need a continuance here. You know, I think the court was entitled to look at the case and say, you know, this clearly doesn't apply. It's distinguishable on just a cursory reading of it, talking about the narrow decision.
But I guess that's the issue, that's what I'm having a tough time with, because obviously the defendant raised the issue, or brought it to the court's attention. The court made that decision that it doesn't apply. I'm not saying the court's wrong, but the defendant's left with no avenue to pursue appeal on that issue.
Well, I think
Even if you would have filed a
appealing it-
motion, it would have been denied based on, you know, not having been granted leave to file. He's sort of stuck without a right to appeal a constitutional argument that he theoretically raised at trial.
Well,
Court
it was
basically
raised.
said your motion to suppress is denied even though it wasn't filed, even though I'm not giving you permission to file it.
But it was raised so late, again,
I
you know,
understand that
13 minutes before trial, and I mean, where does it end? You know, can you raise it now while the trial is going on, and we're going to interrupt the trial? You know, how late do you have to do this? And it had been pending, I believe, 3 or 4 days. So, you know, at least could we do the day before trial? I mean, there were better ways, I think, to address this. And again, this is not a close call, if you're looking at this in terms of whether it might apply to this case. Because I think it really is clear in that Carpenter decision that this is not something that's going to take months and months or even 2 weeks to get a brief together and have both sides, you know, brief the issue. It really was not a close call, like I said.
Thank you for answering my question. You've used your time.
Thank you, Your Honor. I would just ask that this court affirm the report. Thank you.
You only used about 6 minutes of argument time, so I'll give you the whole 5 minutes for rebuttal, if you would like to use it.
Thank you, Your Honor. May it please the court. In response to Mr. Bellucci's argument and a lot of questions that this court has addressed to Mr. Bellucci, I'd like to point out the trial in this case started on Monday, June 25th. The decision of Carpenter came out on Friday, June 22nd. Counsel states to the court during his argument in support of Lee, quote, this is from page 10 of the transcript, trial transcript. Quote, that decision, Judge, just came out last week. It just caught my attention over the weekend, so I filed a motion. I've cited the case. I think that it provides my client with additional rights now to suppress, close quote. Finishing on page 11. So, counsel could not have filed this motion any earlier than he did when the decision came out on a Friday. I suppose if he would have caught that decision on Friday when the Supreme Court released its electronic reports and somehow he was on the internet and happened to come across it, perhaps he could have filed something and got something in front of the court on Friday. But I think due diligence here is exactly what trial counsel did. He saw this case. It came out on a Friday. He's filing it first thing Monday morning before trial. He could not have filed this case, this motion for leave any earlier. Trial counsel was diligent in pursuing this, and he did not have enough time, obviously, to draft a motion to suppress and attach it. He's just trying to get this in front of the court and say, hey, Judge, whoa, I think we got a legitimate issue here. Give me an opportunity to explore this through a motion to suppress.
So even if he would have drafted and attached a motion to suppress, and the court denied the motion for leave, would that issue be preserved or not? You know, the Carpenter issue.
Well, yeah, because it's still the motion for leave. I mean, he's still got that issue for you to decide. If she denies it after reading the motion to suppress attached, she's still denying it on the issue of untimeliness at that point, because the motion to suppress is not being heard, as you pointed out to Mr. Bellucci. Hey, she never had an opportunity to have a motion to suppress, nor did Mr. Beal have that opportunity to present these arguments. So, and I disagree with Mr. Bellucci. He says this case is not on par at all. Whether it's a cell phone and someone's going to a robbery scene and doesn't even use a cell phone, but it's giving out a GPS location off a cell tower, it's a distinction without a difference. Whether it's someone on the internet using file sharing and that information is going out over the internet, it's a distinction without a difference, because in either case, there's a crime being committed. Whether it's someone going to a robbery and they're trying to track the location at the time to prove that that person was at that location without even using the cell phone, it's a distinction without a difference. If someone's using the internet to download pornography, there's no distinction there. So I disagree with Mr. Bellucci's saying this is clearly distinguishable. Carpenter's clearly distinguishable. It's all about location information. Whether it's somebody putting out a file on the internet and they want to trace back and get a location or an address to this IP address, or whether it's a cell phone and the cell phone's sending out a signal to a cell phone tower and they want to get that cell phone location information, it's a distinction without a difference. So I would ask this court to reverse the decision, and if this court believes it's not abuse of discretion, then reverse it for the same reasons it did in justice, and that is to reverse and clarify as to the untimeliness of the motion. And I would submit, I would find it very hard to believe that the court would find in this case that his motion was untimely when he couldn't even have an opportunity to prepare it in the first place when the decision only came out the Friday before trial date. Thank you.
Thank you both for your arguments today. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail you each copy of the decision on the day it is released. And of course, the opinions are also posted on the Supreme Court of Ohio's website. Interesting case. Thank you both for your arguments.
Thank you.
Thank you, Your Honor.